Hello there, I'm Nalini Mahadevan. I'm the principal attorney here at MLO Law LLC, and we practice estate planning and immigration. And I just wanted to talk to you today about trustees and their role and how you choose a trustee. Just a very high level discussion so that you have some understanding of who a trustee is and what they do. So basically, if you have a trust, any kind of trust, whether it's a revocable living trust, a retirement trust, charitable remainder trust, or any other specialized trust, special needs, what have you, in that case, you have to have somebody who administers the trust. So basically, the trustee is a person who administers the trust. And the trustee can either be the person who's putting the assets into the trust, which is called putting the assets into the trust, called funding, and the person who's creating the trust can be variously called a grantor or a settlor, and can also be the trustee, the administrator of the trust, and even in some cases be the beneficiary of the trust as well, as long as they are alive. And then their descendants become the beneficiary after that, or whomever they name. So right now we are talking about trustees. So the trustee is either the first person who's actually funds the trust, or a successor trustee who comes after the first trustee can no longer act because either they are incapacitated or they have passed away. And all these people are actually named in the trust. So all their powers are named in the trust, what they can do, what they cannot do. So read the trust, and there'll be a separate section. The way we drafted has a separate section about trustee powers, and you know exactly what the trustee can do. So the first question is, whom can I appoint as a trustee? So variously you can appoint professionals like corporate trustees, who can be banks or other financial institutions, or trust branches of certain companies. Or you can have an attorney or a CPA, or otherwise you can have a family, a friend. Any of those people act on your behalf. So one of the things we want to really think about is the qualities of head and heart of these trustees. So they should be trustworthy, they should be financially savvy, because there's some amount of financial administration of the trust, depending on who the beneficiary is. And especially if it's a special needs trust, they need to be empathetic with the beneficiary. You should decide that they're empathetic. And maybe they need to have some idea of your family circumstances, so they are aware of what is going on. If, for instance, there is one of the beneficiaries who is receiving the benefits from the trust, is getting a distribution from the trust, and is going through either bankruptcy or divorce or any other kind of crisis in their life, the trustee must have the ability to shut off distributions to prevent assets from being bled into being wasted. So, in a sense, a person who's able to understand money, because they have to invest it, distribute it, file taxes, etc., and perform all the duties that are named for in the trust. So another question we get asked is, should we compensate our trustee? Now, for instance, if it's a corporate trustee, then corporate trustees they usually have a list of fees that they will quote to you. If it's a friend or family member, then that person, I would say, file whatever you think is reasonable, write whatever you think is reasonable as compensation for the trustee. After all, there is a lot of heavy lifting to be done, and they have to do this in addition to their own life. So it's quite an onerous obligation, or it could be, depending on how large their estate is. So consider compensating the trustee for their trouble. And if it's another professional person, they also will quote you fees about how they are going to administer your trust and what they can do for you. So some other questions we get asked are, what's the difference between an executor and a trustee? So the executor or a personal representative is named in the will, and a will is a public document, so the whole world can see the will. And they gather all the assets that are held in single name and doesn't have a beneficiary designation on it. So their responsibility is to gather everything, file all, make all the court filings, assign all the deeds and documents that are required to finally settle the estate and distribute everything to the beneficiaries or the legatees of the deceased person. On the other hand, a trustee is different. A trustee is working in a sphere that is not very private. The trust is not a published document. If everything is done properly while the grantor is alive, then they would have seen to it that all their assets are transferred into the trust name, so that the successor trustee can come in and gather everything up and distribute it to all the named beneficiaries of the trust. So that's the difference. One is in a public sphere, one is in a private sphere, and which is why we highly recommend having a trust as part of your plan for your estate. Sometimes we get asked, what's the difference between a beneficiary and a trustee? A beneficiary is a person who actually inherits from the trust, who gets a distribution from the trust as an income or as principal from the trust. A trustee is a person who manages or is the CEO, administrator of the trust. Two very different roles. Now, they could be one and the same. The same person can be both the trustee and the beneficiary. And that can happen when the grantor is alive. They fulfill all three roles. And when they pass away or are incapacitated, they're still the beneficiary but not the trustee. And then when they pass away, they are the deceased, and they no longer get any distribution, but their heirs and legatees and who are called beneficiaries because they're named in the trust, they will get all the distribution, including the surviving spouse, if any, or surviving cohabiting partner, whomever has been named in the trust. Finally, because we get so many questions, and recently one of our prior clients, he passed away, and his son and mother were in our office and had a lot of questions about what they should do with the trust. Fortunately for them, we had helped them transfer, with our guidance, they had transferred all the major assets into the trust, so the successor trustee had to step in. And we have actually a book called the Successor Trustee Manual, that if you call our office, it's available for sale, and our office will tell you more about it. And there are in it checklists on what needs to be done if the grantor or the maker of the trust is incapacitated or passes away, or if there's a surviving spouse, there are children, what to do, whom to contact, what are your next steps. It gives a very step-by-step guidance in every kind of situation possible. So contact our office. Our phone number is 314-932-7111. Our email is mlolaw@mlolaw.us. So give us an email or give us a call, and all those emails are also on our website, MLO Law LLC, and you can contact us through there as well. And thank you very much for your watching this video, and subscribe to our YouTube feed. And we have occasionally a lot of good stuff on YouTube, both on estate planning as well as immigration. Very nice talking to all of you. Take care.